I don't know about you, Ralph, but I am super excited about today's guest.
I am as well, Yvonne. It just doesn't get any better than this. He has seen it all, has done it all, one of the brightest minds in our entire workers' comp industry.
He really is. And we're talking about Judge Robert Rassp, and he's going to join us today. We are so lucky to have him. He has been an attorney on both sides. He's been a defense attorney, he's been an applicant attorney, written several books. He's an adjunct professor at Pepperdine University, and he is currently the presiding judge in Los Angeles. So, holy cow.
Holy cow is right. I mean, 40 plus years of involvement, engagement in all aspects of the workers' comp system. It just doesn't get any better than that.
And he's so easy to talk to. He makes it sound so effortless. And today we're going to talk about the basics of work comp benefits. It gets complicated, but we're going to try to stay focused on the basics.
Yes, we are.
All right, so let's go talk to Judge Rath, shall we?
Let's do it.
I have to give a disclaimer that the opinions that I've expressed today in this group is the opinions of my own and not that of the Department of Industrial Relations, Division of Workers' Compensation, or the Workers' Compensation Appeals Board.
Hello, Ralph. How are you?
I'm doing great, Yvonne. How about you?
I'm doing fantastic. And hello, Bob, Judge Rasp. How are you?
I'm good. I'm very good. It's good to see you guys.
Good to see you too. Thank you so much for joining us. So I'm going to kick off with a question. I want to know, Bob, what is the last vacation you took and where did you go?
The last vacation I took is about 3 days ago when I came to Baltimore from Los Angeles. So I'm tuning into you from Baltimore, visiting my daughter and having a Friends Research Institute Board of Directors meeting and honoring our outgoing president, Frank Vacci. Dr. Vacci has been with us for 15 years and he is retired now. And we have a new president that's taken over. And we are meeting on a serious basis with some of the issues involving the National Institutes of Health and the Centers for Disease Control and Prevention grant money that's being taken away by a lot of the research institutes, including ours.
It is a time, isn't it?
Yeah, so that was my short answer about my vacation. It's really a working vacation.
Thank you. I was going to say, it doesn't really sound like a vacations, but I'll let you slide. Thank you so much for taking time to join us today. And
My pleasure.
Ralph, how about you?
Vacation. I just celebrated a birthday, and Lisa surprised me with tickets to the Miami Open, the tennis tournament down in Miami, which was absolutely incredible. Inside the Miami Dolphins football stadium, they created this tennis stadium inside of it with 20 of your 1,000 closest friends, you know?
Wow.
Well, Ralph, that raises a question. Did you throw out the first ball?
I wish they would have invited me, Judge. I wish. I have a connection to the tournament. I was a ball boy at the Lipton's tournament, which was what it was called in the 70s. It's where I first got to hit a ball with Chris Everett and Martina Navratilova and Steffi Graf. Over the years, as I served as a ball boy there, they needed sparring partners and somebody was absent. I picked up a tennis racket, started hitting with them. So it was incredible to see it. And it's become, as everything in Miami, just beyond life. It was beautiful and colorful, and the music, food, and all the vendors. It was incredible. It was really amazing.
Well, I saw the pictures and it looked like a lot of fun. So happy belated birthday.
Thank you.
Can't wait to get back together and we'll celebrate and continue the celebration.
Yes, ma'am.
So the last vacation I took was in December, and the family went to London, Paris, and Florence, where I have a daughter who lives there. And so it was a really awesome trip. We had a great time. And so all right, we really are going to get around to talking about workers' compensation today, I promise, listeners. But it's always fun to check in and tune in with our guests to find out what's going on. And, I like to hear what everybody's been up to. So thanks so much again, Bob, for joining us from your working vacation. And today we're going to talk about the basics of workers' compensation benefits. But before we go there, you've been a guest before, and so we appreciate you coming back. I want you to tell our listeners a brief sort of overview of your time in workers' compensation. Tell our listeners what you've been up to and what you're up to now so that they can understand the breadth of knowledge that you bring to the table.
Well, I have been in the workers' compensation industry since 1979, so that makes me old. And started as a certified law student working for a law firm that did primarily defense workers' compensation work in Los Angeles, California. And I've always been in California, and I opened my own practice, law practice in 1982, handling workers' compensation, applicant cases, claimants, Social Security disability cases, about 15 years worth of divorce cases and personal injury cases, but primarily workers' comp applicants work and Social Security disability work. And then in 2018, I was appointed as a workers' compensation judge in downtown Los Angeles. And in 2019, I was appointed as a presiding judge at the WCAB office in Los Angeles, and I supervised 16 judges. So that's my retirement.
Wow. So, I mean, to say the least, you have a very deep understanding of the workers' compensation system. And again, Ralph and I are so grateful for you taking time to join us and share time with us today. So let's just dive right in. What we want to talk about today is kind of break down how benefits are administered through workers' compensation. As we've been chatting in the few podcasts that we've done so far this year, we're talking about, it sounds easy enough, somebody gets hurt at work, we determined that it was caused, through their course of work and arising out of their employment through work. And there are all these different things, but it's really complicated. So now we want to talk about how and what happens when an injured worker is out of work, they're not able to work, and how are they receiving the benefits that are due them through workers' compensation. So I'm going to turn it over to you to kick us off, and then we'll have some questions along the way.
Okay, well, California is a liberal construction state, and we protect the workers of the state of California in a number of ways. We have three kinds of injuries that are recognized by state law. The first is the most obvious, is a specific injury, and that's if somebody has an incident at work that results in medical treatment beyond first aid and a follow-up visit or lost time from work. The second kind of injury we recognize is called a cumulative trauma injury, which is an injury that occurs over time due to what is called injurious exposure. So think about somebody who develops carpal tunnel syndrome from typing for hours a day and number of days a week or for years. And the third kind of injury is recognized as what's called a compensable consequential injury. So somebody has a serious injury at work, perhaps a failed surgery, and they get depressed and they have psychiatric sequelae to the physical injury. If it's results in a catastrophic injury, or the injury itself was a result of a violent act, that can be a psychiatric add-on to it. So there's a lot of claims for multiple parts of body or body systems in California. We are only one of 9 states that recognizes cumulative trauma injuries. So as a result, there's a lot of litigation over that.
Good start. So we've heard about approved body parts. We've heard about causation, whether or not the injury is compensable. How do we get to, and again, thanks for pointing it out, we're talking about California here predominantly today. How do we get to the point when, okay, so a person's been injured, at what point would they start receiving medical care? At what point would they start receiving any kind of payment to help them get by, pay the bills when they're not able to work? Walk us through that.
So in California, there is a 90 period of investigation that is allowed statutorily for the employer or its claims administrator to accept or reject liability for the claim. In the meantime, if it's a person is losing time from work and is not being paid by the claims administrator for the employer, then the injured worker can obtain benefits from the Employment Development Department, state of California, called state disability insurance benefits, which pays the same rate as temporary total disability benefits. Once the claims administrator or the employer have accepted liability for the claim, they reimburse the state of the SDI payments that were made. So there's no overpayment or duplicate payments. And the employer or its claims administrator picks up temporary total disability benefits. And there's 104 weeks of potential temporary total disability benefits payable over a 5-year period from the date of injury. So there's this extra safety net in California if the employer and its claims examiner or claims administrator fail to pay benefits, especially during the first 90 days and 90 days of investigation.
Awesome. Ralph, did you want to interject something yet?
I did, because I don't know of any other state, Judge Rasp, that has anything similar or close to it, right? There are lots of states that have a pay and investigate, but I don't think I know of any other state that has this provision where if the employer carrier isn't paying, there's another source of potential payment of benefits during that time period. Do you know of any out there?
Not that I'm aware of. No, not at all. In fact, the EDD, the Employment Development Department, provides benefits on an unemployment payment side, which, as you probably know, is federally funded for the most part. And then on the other side is also a disability component that pays up to 1 year of temporary total disability rates at state disability. And that's for anybody who is unable to work and sick leave or vacation time runs out and they run out of time. For example, pregnancies or complications with pregnancies. So it doesn't have to be work related to be qualified for SDI benefits, state disability benefits. It's a very generous system. It's funded mostly by payroll deductions.
Pretty amazing. Pretty amazing. I mean, a state that truly is trying to take care of their folks or employees at the very, very common level, if you will.
Okay, so you mentioned temporary disability benefits, and let's talk a little bit about, so if it goes beyond temporary and there's permanent disability benefits, at what point does that start to factor in, or walk us through how that is determined?
So an injured worker is receiving medical treatment through usually the medical provider network that is provided through their employer's claims administrator. And the employer, as a general rule, has control over who the treating doctors are. If there is any dispute between the injured worker and the employer or vice versa over their disability status, whether they have reached maximum medical improvement or not, those issues are resolved through a separate medical legal process in California, where at the expense of the employer or its claims administrator, the injured worker is examined by a doctor that is selected through the state panel qualified medical evaluation process. So the Division of Workers' Comp has a medical unit that manages the licensed qualified medical evaluators in the state who are neutral, who don't have a bone to pick, don't have an agenda. They have an ethical obligation to provide accurate medical legal reporting to discuss the diagnoses, the disability status, if the injured worker has reached maximum medical improvement, to establish if there's any permanent impairment using the 5th edition of the American Medical Association Guides to the Evaluation of Permanent Impairment. And then we have a formula that is plugged in with the whole person impairment ratings that come from the doctors that account for the injured worker's age at the time of the injury, their occupation at the time of the injury. There's an adjustment factor of a 40% increase over the whole person impairment rating. And then we have a money chart we look at. So the injured worker is paid weekly benefits as permanent disability advances. It's capped at $290 a week, which is deducted from their ultimate settlement at some point later.
Okay. So you just mentioned, what the maximum is, but is that so people don't get paid 100% of what they're normally earning if they're out on a workers' compensation claim? Is that correct?
That's correct. The temporary disability rate changes every year based on the U.S. Department of Labor statistics that come out at the end of March. And uh, currently, I believe the temporary disability rate is equivalent to about 2/3 of 130,000 a year. So it's pretty generous. It covers probably the super majority of the workers in the state of California. Those are people who are higher earners, usually have a disability policy, either privately or through their employer.
Sure. Okay, Ralph. I mean, there's more questions I have, but I want to let you get some good questions in here because I know I can see your wheels are turning.
Oh, yeah. Yeah, because once again, California's system is so very different than most states out there, even as they provide the care. So let's talk about that for a minute, Judge. Employer carrier responsible for putting up a network, right? And it's through that network of physicians and services that the injured worker receives care. Is that right?
That's correct. And the quality control of that care, and the word quality is really kind of a vague statement on purpose because there's different perspectives of what's considered quality, is established by the medical treatment utilization schedule that is mandated by California state law. The MTUS is based on the ACOM guidelines, American College of Occupational Medicine guidelines. And those have been adopted in California almost for 2 decades. As they've been updated as well. In addition to that, we have a prescription formulary that went into effect in I believe it was 2013, that also is subject to change as well. So, there's no, for the first like 10 days, there's a waiver of that. So if a doctor in an emergency room wants to prescribe a Schedule II narcotic, they can without having to go through the utilization review process. So we have built into our system a utilization review and independent medical review system that's essentially the same thing for general health coverage in California and other states, where there's an actual review and a peer-to-peer discussion of something that may be denied. So, for example, a 2-level fusion in the lumbar spine may require initial denial by the claims administrator, saying it's outside of the scope of the medical treatment utilization schedule. The injured worker hasn't had enough conservative care, and therefore we're not authorizing the surgery. Well, then there's an appeals process there that the injured worker can go through, not through the courts either. We cannot hear those unless there's some flaw in the system, such as a delay of denying benefits. So we have a very robust kind of oversight system for medical treatment in California.
So, Judge, that you just mentioned, right, is different than in most states where it is the workers' comp judiciary who gets to listen to and ultimately decide issues regarding medical care. Here in California, separate entity does that. Is that right?
Yes. So just to walk you through it, Dr. Smith, the treating doctor, issues a request for authorization for a 2-level fusion, for example. And the employer has essentially 5 days to authorize it or to request more information from the requesting physician. If ultimately they have 14 days from the date of the request for authorization to authorize or deny that requested treatment. And that treatment could be surgery, it could be physical therapy, it could be a prescription medication, it could be anything. The injured worker then has 30 days to file a request for independent medical review. And the state of California has a contract with Maximus Federal Services that does the independent medical review. They issue a notice of acknowledgement. The parties have X number of days, I think it's 10 days or 15 days to submit whatever they want in support of or against whatever the request was. And Maximus Federal Services then will either uphold or reverse the denial of treatment for that particular spinal surgery. If there is a delay, and there certainly are a lot of them in that process, then the injured worker can appeal to a workers' comp judge. But the only time that we can step in and make our own medical determination of authorization of treatment is if there was an untimely utilization review to begin with. And a lot of times that happens because there's, issues over it was faxed, it wasn't faxed, it was emailed, it wasn't emailed, that kind of notice issues that come up. So all the judges will eventually hear at least one or two medical dispute issues regularly. A lot of them are in brain injury cases. Yvonne, you'll be interested in this. A lot of brain injury cases where the injured worker is admitted to an inpatient program or in a residential program or even an outpatient program for rehabilitation from a brain injury. And the insurance companies go crazy with that because they think it's an open book to keep renewing it month after month after month. And in many brain injury cases, that's true. So we have case law that says there has to be a change in circumstances to justify stopping those benefits. That's called the Patterson case in California. So the burden is on the defendants, on the employer and the claims administrator to say, hey, wait a minute, this person is better or they're not getting better. Why are we wasting our $30,000 a month for an inpatient program? So that issue is really, a significant one that we see happening quite often in those types of cases.
Thank you so much. So incredibly interesting because, of course, as you will know, state to state, these rules and these methodologies, right, to resolve conflict change. So it's interesting what California has done to be able to come up with a solution that works for them.
Yeah, we have 216 trial judges in California, located at 21 different district offices. I'm the second largest in Los Angeles. Like I said, I supervise 16 judges. The next largest is Van Nuys. They have 22 judges. They're splitting that up right now too to have two different supervisors. And so at the trial level, and I still hear cases because I like to keep my hand in it. At trial level, if somebody loses, there's always somebody who loses in court. They have 25 days to appeal to the Workers' Compensation Appeals Board, the main appeals board in San Francisco, which are 7 commissioners and 3 deputy commissioners. And that's an intermediate appeal. Everything is in writing. There's nothing, no oral arguments or any of that. And then if anybody is aggrieved by the decision by the appeals board panel, consisting of a combination of 3 commissioners or deputy commissioners, then they can take the case to the California Court of Appeal. And if they lose there, they can take it to the California Supreme Court. So we do have a tie-in as an administrative law system that goes into the appellate level as any other case would go from the superior court system, from the civil courts.
It amazes me, Yvonne, because there are states out there that do not have in their entire state the number of judges that you oversee, Judge Rassp. So to talk, when I hear over 220 workers' comp judges throughout the state, trial law judges, holy cow, that's, I mean, there are states that have 4, 5, 6 of them in the entire state. You've got
I know in Florida, because Judge Langham and I are very close friends. We're all good friends with Judge Langham. I know there's 31 judges in Florida.
Yeah.
I get it. But California, you got to remember something. We are serving 49 million people.
Mm-hmm.
Okay, that's the population. So there's got to be that proportion. People, it's an access to justice issue. You want people who live in remote areas of California, and God knows there's a lot of remote areas in California, to have access to a judge and the ability, if they're hurt at work, to be able to be heard.
So I want to take a couple steps back. You guys jumped right into some really complex, scenarios. You talk about brain injury and 2-level spinal fusion. So I'm going to walk it back a little bit.
Sure.
Because as we know, as we always talk about in the comp system, yes, we have those kinds of cases, but the vast majority of cases are not overly complicated. People get hurt, they strain their back or they hurt their shoulder or something more minor. So I want to talk about a few more basic concepts. So, and I think this is a pretty common thing that people wonder that comes up a lot about the comp system. So, Judge, I know that there's a provision in California, but I want to ask you, and then we'll talk about it. Can a person see their regular doctor if they get hurt, they have a cut, or maybe they just sprained something, they want to go see their regular doctor? Is that allowed?
Of course it is. Even better, we have a statute in our labor code that allows a worker to pre-designate their personal primary care physician in the event they get injured at work. The unions are supposed to have carried the ball on that, and over the years they really haven't. They don't have a dog in the fight per se, but and it's unfortunate because I know if I got hurt at work, the first doctor I'd go to is the one who's got all my records and has my history and knows my medications, instead of me having to go to some buddy I've never met before and doesn't have any of that information. But we do have a formal way of pre-designating. It's just not used enough. And we have a labor code section that does allow an injured worker to go outside of the medical provider network to a doctor of their choosing at their own expense. What does that mean? It means that they have to pay the co-payments and deductibles and all that, and they don't get that back. Plus, you have to have the doctor willing to treat a work-related injury, and a lot of doctors don't. They don't like the reporting requirements. So the answer is yes, but there's a lot of buts after that. Yes.
Right, but it is allowed in California, but I don't think it is in Florida, is it, Ralph?
It's not. It's not. One of the major differences, yeah.
So it goes, and we talk about that a lot on our different episodes. So like what is the case in one state is really only the case in that one state, right? Every state has its own system. So that's one of the things that I think we all find very fascinating about workers' compensation. So let's see, a couple of other things I wanted to bring up is like we hear about utilization review, and you mentioned independent medical exams. And so how in the world, if I'm just an injured worker, or if I'm somebody that has gotten an injury at work, how do they navigate all of that stuff? And what should they know? Like, who do they look to help them navigate that process, or who should that be?
Well, that's a loaded question, Yvonne, because I'm a total advocate of seeking legal counsel. This is a complex system for anybody, and I don't care what state it is. It's controlled primarily by, the lobbyists for the interest groups. And to have an injured worker, the first thing they're going to be worried about in an injury is whether the employer is going to fire them. A lot of people don't even report injuries. They're afraid of the consequences of being terminated from employment. So there's a great deal of hesitancy to do that. But, in order to really navigate the system, the best way to do so is through counsel. It's not a lawsuit, it's a claim. We do have it embedded within our district offices and information and assistance officers who are there to talk to injured workers, to talk to employers, and to help them navigate the system without giving legal advice. But, injured workers do better when they have legal counsel. I mean, ask any of the folks that were behind the reforms in California. They've done their studies. They see that people who are represented by counsel do better in the outcomes of their cases.
But what about this thing that we hear pretty commonly that, once a case, you think of a injured worker getting legal counsel, then you automatically think, okay, that claim is going to go into litigation. Doesn't litigation drive up the cost of the workers' comp claim? And isn't that part of what's making the system costs go high?
Well, there's allocated loss adjustment expenses, which is the fancy, underwriting name of litigation expenses and frictional costs. That's what it's called. Taking the deposition of an injured worker is considered a frictional cost. Having the injured worker's attorney take the qualified medical evaluator's deposition is a frictional cost. So yeah, of course, when somebody gets a lawyer, it's going to be more expensive for everybody. But at the same time, the outcome of the case is much more favorable, much more of a balanced equation between the employer and the injured worker. Unfortunately, California has, I think, the second worst return to work rate for injured workers. I think the worst state is Texas. Sorry, Stuart. And so, and I don't know what the return to work rate is in other states. I don't even know if that metric is even addressed. I mean, I'll ask you in Florida, Ralph, you're an attorney. Do you know any of those statistics?
They are not published. So generally, we do not know, other than what we get from individual vendors or contractors to some of these entities. We really have no idea what's happening on a return to work down here.
So, I mean, this is going into a really good conversation, so I'm going to keep pushing it. Let's go back to California and let's talk about, so Judge, you're saying that you feel that an injured employee should seek legal counsel to have the best outcome for themselves. But what about, why is it so difficult for employers? We hear that when the communication breaks down, that's one of the things that causes a lot of frustration with the injured employee. And therefore, they're going to go looking for, a legal counsel to represent them. Why is it so difficult for the employer to have open lines of communication with the injured employee to avoid all that? Wouldn't it be so much simpler if the employer just communicated and helped walk the injured worker through what needs to happen?
In an ideal world, you're right. And I spent, 4 decades in this system. And what is really kind of sad about it is that there's not much outreach to the employer community. The feedback I have gotten over the years is that a lot of employers, especially small businesses, even the larger businesses, think of injured workers causing them to have their insurance premiums go up, which is not true. Premiums in workers' comp are established by 2 things. One is payroll, and the other is the job classification. And that's throughout the country. But for some reason in California, there's this idea among employers that if somebody files a claim for workers' comp, that they're going to get canceled, they're going to get surcharged, their X mod is going to go up. And in some cases, it does go up because they don't have a safe working environment and they have a lot of claims. So there's a lack of education in the employer community. There's too much pushback in small businesses to workers' comp claims. Even though we have a very good anti-fraud sections of the labor code and the insurance code in California, but there's a lot of pushback and a kind of a lack of knowledge on the part of the employer community.
So how can we, I've been involved in, many situations, scenarios, conversations, what have you. And one of them I'm gonna refer to our friend Joseph Sousa, who is the workers' comp program manager in the city of San Diego. And anytime we invite him to a conversation about, such things, he speaks very highly of, the more an employer can build a culture of wellness and help the employees feel that they are regarded as important members of the workforce, then the better things go. So who is responsible for bridging the gap with what we're talking about? You're saying that there's not enough outreach to employers and that's unfortunate. So where does that come from? Who needs to fill that gap?
I think the legislature does in a lot of respects. If there's some sort of state mandate to build into the system of workers' comp some sort of greater employer responsibility. We used to disguise all of this by vocational rehabilitation, which was repealed in 2009. We no longer have that. We have supplemental job displacement benefits, which is basically $6,000 worth of educational expenses. We have a return to work fund, which is another $5,000 that the Department of Industrial Relations will pay someone where the employer does not take them back in regular, modified, or alternative work. So there's some remedies for injured workers, but they're not that valuable. It's a question of incentive and changing the incentive on the part of the employers. Employers think that workers' comp is the cost of doing business, and in some ways it is. The other is to reduce frictional costs, and they've come up with different theories of doing that, and it just doesn't happen. There's been talk of changing the legal threshold to prove liability for cumulative trauma injuries to a higher threshold than substantial cause, something along that line instead of a contributing factor. So there's a lot of theories out there, but there's no unity of purpose in the employer community. And that's because, some employers do a great job of, and the city of San Diego should be a model to everybody else familiar with it. And Mr. Souza is great at what he does, but that's the exception.
Okay, so it's now time for us to think about wrapping it up. So Ralph, or Judge Rassp, what did we not cover when we're talking about, the basic, the benefit system that exists within workers' compensation? What did we not touch on?
Judge, I'd like to ask you, clearly you and your other judges throughout the state, you hear a lot of cases, you listen to disputes and ultimately make decisions. Give me an idea of what does that volume look like as compared to the full volume of claims out there, right? Because I think in most states, those issues that go to a judge or ultimately get decided by a court, are a small percentage of the larger volume of claims that's out there. Is that also true in California?
Yes, with a caveat. The caveat is that all settlements of workers' compensation cases have to be approved by a workers' compensation judge. So it's not like the civil system where a personal injury case, car accident case, parties settle the case outside of court. All the court cares about is a one-page dismissal of the action. That does not happen in California. So all settlements of workers' compensation cases have to be reviewed by a judge, and for adequacy. And the word adequacy is not defined in the regulations or the statutes. So it's essentially case law that says, that the settlement has to reflect the risks of litigation. It has to be within the range of best case scenario, worst case scenario, based on the evidence that's submitted in the case. So it's a checks and balances. And I like that part of it, that all of us have to review settlements and approve them. And a very large percentage of them are not approved. And we set those for hearing. We, ask the parties, why are you settling this? Give us a better reason. What's your offer of proof? So, what percentage of cases are litigated in California? Probably a very large percentage. I don't know the statistics, but also a very large percentage of them settle out of court, or they settle with a judge's approval. Everything settles out of court, but, everything is subject to judicial scrutiny. And that's what I like about our system here.
Thank you. That's, that used to be, I think, throughout the country, what most states required, approval by a judge of that settlement. And then over the last 20, 30 years, we have seen states get away from that. There used to be a time, where the thinking was, a judicial officer needs to make sure that there's fairness in the settlement. We seem to have gotten away from that in multiple states. I've wondered many times why that is, why that particular component has changed. Why does California still keep that review system where the judges have to review and approve that settlement?
The simple answer to that question, in many states that you're talking about, Ralph, are employer-driven systems. In California, we have Article 14, Section 4 of the California Constitution that says that there's a mandate to protect injured workers of the state of California inexpensively, without encumbrances and expeditiously. So that language in there is the parens patriae of the state, constitutional mandate, to have the state take its proverbial arms and wrap it around the workers of the state and to protect them. And that's really the constitutional mandate that all judges have when we take our oath to, swear to the U.S. Constitution and to the Constitution of the state of California, that we provide benefits to injured workers of this state expeditiously, inexpensively, and without encumbrances. So it is from that language, as constitutional language, that all of our statutes in the labor code and the regulations that ultimately result in judicial review of everything, resolutions of cases, is mandated by the Constitution, not just by the legislature.
Thank you. That explains it, because that's exactly what's missing in all of those other states that are changing the system very differently. Thank you.
So thank you so much again, Judge, for joining us today. I don't think you mentioned in your overview, maybe you did, maybe I just don't remember it, but you're also an adjunct professor.
Yes, I teach workers' compensation law at Pepperdine Caruso School of Law. In fact, I'm going to be teaching next year, I think the winter semester for 2026. I look forward to it.
Well, thank you so much for joining us. I wanted to make sure and mention the fact that you're an adjunct professor. I've worked with you on a number of occasions to bring educational sessions forward, and it's always a pleasure. I love working with you. You break it down in such a digestible, easy manner, and then you just sit there and cite code like you've got it memorized in your head. So clearly you do.
Well, I love working with both of you. You guys are a joy to be in person and by virtual as well. I look forward to seeing you in San Diego soon this summer, and Ralph, as soon as possible. We'll see you probably in Orlando, and because I know I'm going to be on some panels there. And I just we all get together. We have this little coterie of people that are really cool people that I like to associate with and consider to be my friends.
Oh,
Judge,
thank you.
I echo that. I'm so grateful. I think all of us are, who are associated and have been part of the system for a really long time. We're so incredibly thankful, because you really are, just as Yvonne indicated, you give us substance all the time. We learn from you, your experience, your analysis of these different components, which, as was hinted already here, it's a complex system, no matter what state you're in. So we're so incredibly thankful for your leadership, your analysis. You really are one of the thought leaders in this entire industry. And so we're so incredibly appreciative for all the time that you give us and that you always teach us about it. Thank you so much.
You're welcome.
Thank you. So, like we always say, it's a wrap for this episode. And until we see you next time, hasta luego.
Hasta luego.